Good evening, everyone. My name is Kelechi Onyobia. I am the Director of Public Affairs and Religious Liberty Department, as well as the Community Outreach Department at Heritage SDA Church. I welcome you to the second week of a 4-week session titled March Information Series, where we intend to provide information and provide resources to our immediate and extended community on different areas that are of interest to our community. Last week, we dealt on immigration, and this week, we'll talk about wills, estates, trusts, probate, and all related to that topic. This evening, we have 3 experienced attorneys to make presentations and guide us through all the questions that we may have on the process and everything related to wills, trusts, estates, and probate. Before we continue, before I introduce our presenters and lay out the ground rules, we invite our pastor to give us an opening prayer.
Let's pray. Father, we are thankful for this evening, for allowing us to be on this virtual call today to learn vital information to help us as we are navigating life and understanding the legal system. Be with us now as we go through this time together. Bless us, Lord, and teach us, Father, and guide us, Father, I pray. In Jesus' name, amen.
Amen. So the ground rules are that everyone is muted. The only ones that can be seen and that can make presentations or speak the 3 presenters, myself, the pastor, and our 2 assistant facilitators, Chimo Bim Onyekwere and Chipo Onyekwere. So the way it will work is that the presenters will have 10-15 minutes each to make a presentation, and thereafter questions will be asked of them from Chima and Chipo, read out of the chat function. So if you have a question for the presenters while they're presenting or after their presentation, please type it in the chat function. And then Chipo and Chima will read out the questions and engage with the presenters who will be responding to the questions. Our first presenter will be Ms. Tamara Jordan. Ms. Jordan is a principal attorney of the law office of Tamara Jordan PLCC since 2005. Ms. Jordan represents clients in guardianship, surrogate, and estate matters. Ms. Jordan obtained her bachelor's degree in philosophy, politics, and law at Binghamton University and her Juris Doctor at Northeastern School of Law. Ms. Jordan accepted a competitive judicial clerkship with the Superior Court of New Jersey. After completing her clerkship, she accepted a position with an insurance defense and subrogation law firm in Long Island. I guess it's a little too late for me. Ms. Jordan also serves as a small claims arbitrator, guardian ad litem, referee, guardian, court evaluator, and court-appointed attorney for alleged incapacitated persons throughout the 5 boroughs of New York City. Tamara Jordan is admitted to the New York Bar, United States District Court, Southern District, as well as the Eastern District of New York. Our second presenter is Ms. Maureen Pritchard. Ms. Pritchard is the principal and founder of Whitley Pritchard and Associates PLCC, a boutique law firm that specializes in trust and estates, individual and business succession planning, and business entity formation. With over 15 years in the legal field, Ms. Maureen is a staunch advocate for providing clients with the information they need to enable them to make informed decisions about their most valuable assets. During her legal career, Ms. Pritchard has litigated commercial and real estate cases in New York State courts. As an estate planning attorney, she helps families to plan their estate by helping her clients to create living trusts, last wills, and testaments, power of attorney, and healthcare proxies. She also works closely with clients who have special needs and have been appointed by the New York Court as counsel for individuals with incapacities. Maureen Pritchard is a graduate of Bernard Baruch College and New York Law School. She served as an extern to Honorable Jenny Edwards, Justice of New York Civil Court, Kings County. And our third presenter is Pamela A. Walker. Ms. Walker is the principal of the Walker Firm PLCC. She's been in private practice since 2003, and she's licensed in New York State, Eastern and Southern Districts of New York, and the United States Supreme Court. Ms. Walker practices in the areas of surrogate court, probate administration, real estate, tax certiorari, as well as Article 81 guardianship. She's a member of the New York State Bar Association, real property law, trust and estate law, and elder law and special needs sections. She's vice chair of the mentorship committee of the elder law and special needs section. She's also a member of the House of Delegates of the New York State Bar. On a personal basis, I have known Ms. Walker for quite a few years. We're not going to date ourselves, and our friendship has been a source of blessing to me, and it is good to see her once again. And so with those said, I will ask that we start the presentation and ask either Chukwu or Chima to start asking the 5 questions that Ms. Jordan sent over. Thank you. Chima, you're muted.
Sorry, just one moment. All right. So we're going to get started with these questions now. I'm going to ask the first question. Who can serve as a guardian? This is the guardianship quiz. Who is in control of your affairs? These 5 questions will help you learn more about your guardianship and your rights. The first question is, who can serve as a guardian?
Anyone can guess. You could put it in the chat.
Yes. Yes.
Yes. Anyone appointed? We have someone saying anyone appointed. Anyone else?
And so the answer to the first question is that it can be anyone. It could be a friend, it could be an agency, and it could be a family member who can serve as a guardian.
All right, so let's move along. What is the role of a guardian? Please put your answers in the chat. Everyone doesn't have to answer all at once.
And you can give the multiple choice.
Okay. All right. So what is the role of a guardian? Is it to make medical decisions, to manage your finances, to choose where you live, or all of the above? Someone is saying, we have here Pastor Grissom saying, to take care of the affairs of someone in the absence of a person, or all of the above. Okay, we have Joshua Goha saying D, all of the above. All right.
And the answer is all of the above. So you guys are doing wonderful. A guardian can make decisions with regards to your medical. They can also manage your finances, and they could also choose where you live. So great job.
All right, let's move along. Will the court appoint an attorney to represent me as an alleged incapacitated person? AIP. Generally speaking, yes or no?
And I'll respond. And I'll respond. It's okay. And so generally speaking, yes. Oh, the pastor said no, but it's generally speaking, yes. And we're almost finished with the questions, so you're doing great.
How soon will the judge decide my case? Today, tomorrow, next week, 28 days, or depends?
And repeat that question because we're going to come back to that later on. Because this is a very
answer saying
question. Yes.
Someone is saying depends. This is Okechukwu is saying depends. All right, I'll read it again. How soon will the judge decide my case? Today, tomorrow, next week, 28 days, or depends?
And the answer to that is that it does depend, but each of those today, tomorrow, depends 28 days are going to be very important as we continue with the presentation. And then we're on to one more.
Okay. All right, our last question, our final question. Who is paying for all the legal fees and costs for the guardianship case? The government, you, or someone else? All right, the pastor is saying you, Okechukwu is saying you. Joshua is saying you. Any other answers? All right.
Thank you so much. So thank you all for participating in these short 5 questions, and we can go forward with the presentation. And thank you so much for moderating.
You're welcome.
The answer is you. I see it in the chat. The answer is it could be you, it could be someone else, or it could be the government. Thank you for the follow-up, Pastor. And we're just waiting for the presentation slides. And as we wait for the presentation slides, I just want to introduce myself once again. My name is Tamara Jordan, and I just want to thank you all for taking time out of your busy schedule on this late Thursday evening to learn about guardianship, to learn about trust, to learn about estate planning, to learn about surrogates. Your time is not wasted, and feel free to post any of your concerns in the chat. We are here for you. The reason why myself and my esteemed colleagues are here today is because we want to provide as much information for you, for the community, for the church, so that you are educated, that you are empowered, and that you feel encouraged. The reason why I wanted to come on is because so much can be said about guardianship. Oftentimes we hear about guardianship in the media. I don't know if you've been hearing about it lately, about Wendy Williams, per se. She's actually under legal guardianship. So here we are. Someone in this type of position who has amassed great wealth and now is under court supervision. And so oftentimes, and here it is. Thank you so much. So my presentation is entitled The 3 Threats of Guardianship. Who's in control? And oftentimes we don't think about guardianship until a crisis occurs. And whether it's you or a loved one, this is not only an important issue, but this is an issue that affects all of us. And so I want to just walk you through the process as to why I believe that guardianship is essential for you to know. And then next slide. Thank you. So here we are. My role, as an officer of the court and as a licensed attorney, I handle guardianship cases under what is called Article 81. But don't be concerned about the word Article 81, I want you to have just a good understanding of what a guardianship case is. And a guardianship case, as it states in the presentation slide, is a court case where a judge can decide whether to appoint a guardian. A guardian is someone who can have legal authority. Legal authority to do what? Legal authority to control your day-to-day affairs, including managing your finances. And why is that important? Is because think about it this way. Say you have built your career, taking care of your family. You've dotted every I, you've crossed every T. And then you find yourself in court, find yourself under court supervision, find yourself talking to a bunch of strangers, making decisions about your needs, about where you live, like we had the 5 questions earlier, about your day-to-day activities. This is sweeping authority. And if you do not have your wishes memorialized in writing, and my esteemed colleagues will be able to speak about those issues as well, the city of New York, the judge can make decisions about your quality of living, can make decisions about where you live, can make decisions about how your money is supposed to be spent, can make decisions about your day-to-day affairs. And so this is something, no matter if you have $1 or you have $10 trillion, this is something that you should know because it happens to so many people, and this is something that is often overlooked. Next slide. And as we continue to wait for the next slide, one of the key issues about guardianship is that oftentimes people don't realize not only how intrusive it is, but it's scrolling down. Okay. So as we continue with the 3 threats of guardianship, thank you. These are the 3 things that I want you to think about during this presentation. Number 1, what's the first threat? Losing control. You no longer have the choice to make decisions on your own. Number 2, losing your right to privacy. What was supposed to be a private matter, what was supposed to be a personal matter, is now part of a court case. And 3rd, leaving the doors to predators. And why is that important? It's because let's say, for example, you have a long lost relative you don't particularly care for, and you haven't heard from her in years. And all of a sudden, she comes out the woodwork and says, I want to serve as your guardian. And this is not what you wanted. But because you did not put this in writing, now the judge has to decide whether your long lost relative should serve as guardian. Oftentimes, the court would prefer for family members to serve in that capacity. And so now you find yourself not only before the judge, but now you find yourself having to fight for your right to make decisions on your own. And as we continue on, and thank you. What else can happen? These are bonus things that I wanted to share. You're losing time. Now, instead of you taking time to spend time with your family, to enjoy your activities of daily living, now you have to defend yourself in court. And what else can you possibly lose? Money. Guardianship is a very expensive process. And this is not something that you want to happen, but this is something that you're going to have to invest in order to allow the judge to know that, number 1, you don't need a guardian, or number 2, if you do need help, should you be considered incapacitated? And the other bonus is number 5, letting the government decide your fate. As I stated earlier, if you don't have your wishes known and you don't have anything memorialized in writing, such as a healthcare proxy, a living will, a power of attorney, even down to a last will and testament, now you have the government deciding your fate. And we can continue. As I go into in greater detail, number 1, losing control. Everyone knows what that means. You no longer have the right to make decisions on your own. Now you may be faced with a guardian who's going to make decisions, and those decisions may not be aligned with your wishes. Those decisions may not be aligned with your beliefs. Your decisions may not be aligned with how you spend your money. But now you're at the in to put it plainly, you can feel like you're at the mercy of strangers. So that's threat number one. And then threat number two, losing your privacy. Your affairs are no longer private. Your business, your decisions, your choices, as I stated earlier, are part of a court case. The judge, court appointees. Who are these court appointees? These court appointees are the court evaluator. The court evaluator serves as the eyes and the ears of the court, and they have to provide a report, a recommendation to the judge as to whether or not you should have a guardian appointed. You also have your own attorney. It could be privately paid, or it could be one that's appointed by the judge, and that I referred back to the earlier quiz. Or you could also have a court examiner, someone that if a decision is made that you need a guardian, a court examiner is going to look at the accounting. There's so many people involved in this process. And when you have many people involved, that means there's going to be more money that's going to be spent. And these individuals, the judge, the court appointees, and other attorneys, to name a few, will review, will examine, and discuss your decisions as part of a court record. And I see the questions in the chat. When do people typically get a guardian? Great question. People typically get a guardian if there are issues with this person handling their finances, or there could be a situation where a person becomes ill and they're hospitalized, and their wishes are not made known. So I'll give you a great example. Say, for example, someone goes into the hospital. They don't have anything in writing to express what's going on, and they've been in the hospital for a significant amount of time. Sometimes the hospital will file papers asking the court to appoint someone to take care of you, and it could be temporary or it could be permanent. But you find yourself needing a guardian, or the court makes a determination that you need a guardian, if no one knows what your preferences are, because you're unable to advocate for yourself. Sometimes you can verbalize it. Sometimes you may suffer from a physical condition. Sometimes you can suffer from a mental condition. It really depends. But the judge is going to make a determination whether you have the ability to manage your affairs without a guardian being appointed. And then here's another question in the chat. How often can you switch guardians? Now, terminating the guardian proceeding is another proceeding all by itself. And it could be very difficult at times to terminate a guardian. And so you can have a guardian for a limited period of time. Say you just need a little bit of help. It's called a person in need of a guardian, where the court is not going to determine that you are incapacitated. You're just someone that needs help. And the reason why that's important, and the reason why that's a distinction, is because you don't want that label to be incapacitated per se. If you're found incapacitated, that means that the city of New York in this presentation has deemed you unable to make decisions on your own. Whereas a person in need of a guardian is someone that recognizes that they have a need, they do not want to be labeled as incapacitated, and they still have the right to make decisions not only without that label, but without the determination. And then here's another question. Is guardianship and power of attorney the same thing? Great question. So a power of attorney is a legal document, which my colleagues will go into greater detail, where you're able to designate in writing what your wishes are. Whereas guardianship, it could be a full-blown hearing, where a determination is made as to a determination is made as to whether or not you're incapacitated. So a power of attorney does not render you incapacitated. There is no legal finding as to your ability to manage your affairs. You can execute, that's what they call execute, a power of attorney without having a guardianship proceeding. And that's actually preferred because guardianship is considered, and I'll go on in my presentation, but I'll repeat it. I'll say it earlier. Guardianship is considered a last result. So if you have your affairs in order, if you have a healthcare proxy, a power of attorney, a living will, a last will and testament, the court does not want to disturb those documents because you've made your wishes known. And so if you have those documents in place, it may be a little bit difficult for someone to come in and challenge. Not to say it's an absolute, but at least you have a good starting point to say, I've already made my wishes known. I had the capacity to prepare and to execute those documents. And these are the documents that I want to be carried out. And I appointed my agent to do so. And I see another question. Thank you for the question. Are guardians regulated so that they can't take advantage of the person who oversees the guardian? Excellent question. Absolutely. And so when a guardian is appointed, they have to complete several things. Number one, they have to do an initial report, a 90-day report. Then they have to do annual report. And the court examiner that I just referred to, that person will go ahead and they'll look at the accounting. So every penny, every dime, every dollar that is spent towards your care is going to be scrutinized. And that guardian is all they don't always, but some guardians receive compensation as well. So this is going to be a closely monitored case with regards to the expenditures, with regards to how your money is spent, and also with regards to your care itself. So thank you all for those questions. And threat number 3, my last threat, leaving the door open to predators. As I indicated earlier, you have a long lost relative who comes out the woodwork that you're estranged from, who you do not want to manage your affairs, but now has decided to come in and petition the court to serve as guardian. So the point of number 3, and this is the point that I want to emphasize, is that your money, your time, your life is literally at stake. You may end up paying not only to defend yourself, not only to defend you, but the same people who filed a case against you. And the reason why this is important is, here it is, you're in guardianship. And you say, I don't need I don't need a guardian. I don't need anyone to take care of my affairs. The court can decide that everyone has to get paid. I'm going to make it in as simple as possible, but the court can literally have the power to decide that the family member who came out the woodwork to sue you, to petition, to serve as guardian, the court evaluator who serves as the eyes and the ears of the court, the court examiner, your own attorney, all of these individuals, how do they get paid? They can get paid from using your assets. It's legal and it happens in these guardianship proceedings. And so I just wanted to let you know that these are the 3 threats of guardianship. I urge you to, listen to my esteemed colleagues about the impact it is. Oftentimes when you don't have anything in writing, now the court appointees have to figure it out. And so as a recap, you can lose your choices, you can lose your privacy, and you can leave the door open to predators. And those are the 3 threats of guardianship. And I thank you all for listening to my presentation. And I have completed my presentation at this time. Thank you. Does anyone have any other questions?
Thank you. Thank you so much.
Thank you so much.
Ms. Jordan, we shall proceed to Ms. Pritchard. And please keep the questions coming. And I will remind the presenters to please, stick to the format, do the presentation. I know, there's always an urge to look at the chat, see what questions are coming in, but we hope to be able to go through the questions at the end of the presentations. So please, let's keep it that way. Thank you so much, Ms. Jordan, and Ms. Pritchett, you have
Thank you.
the floor. Thank you.
Okay, thank you so much. Thank you everyone for joining us this evening. I know it's late and you probably had a long day at work, but I am delighted that you're here, that you could join us and participate in these planning discussion and presentation. The information that we're sharing with you is information that can help you greatly in making sure that everything you own and everything you love and everyone you love, is protected. So my presentation is going to be on estate planning, wills, and living trusts. And as you heard previously, please jot down your questions and I will answer those questions at the end of the presentation. You can go to the next slide. Thank you. I think if you can click on, yes, go back up one slide, please. Thank you. There you go. So the first thing I want to touch on is what is an estate. I speak with a lot of people, a lot of individuals on a daily basis, and oftentimes they are confused about what an estate is, or they think that only wealthy people have an estate. So basically, what does your estate comprise of? So your estate is made up of everything that you own. So if you simply add up all of those things, you, like most people, will find that they own a lot more than they think. So your home, bank accounts, investments, retirement accounts from your employer, life insurance policies, personal belongings. If you start adding all of those stuff up, you will find that you do have an estate. Next slide, please. So why plan? Why do estate plan it at all? Why not just leave it as it is? After all, when you pass away, who cares who gets your assets, right? So as my colleague has stated earlier, you want to plan because you want to be able to have some measure of control about who is in your life, who makes decisions for you, and what those decisions are going to be, right? So typically, most people that plan their estates look at, who is going to get my assets after I pass away. But your estate planning is a lot more than what happens after death. So your estate plan also include what happens during your life if you're incapacitated. If you're sick and you're in the hospital or you're in a nursing home, or even if you're at home and you can no longer make medical, legal, and financial decisions for yourself. Who makes those decisions for you? And are the decisions that they're making, would you be okay with those decisions? Okay, and then of course, as we said, as many people are aware, you also plan so that after death, you know exactly who your assets are going to. Next slide, please. So when should you start all this planning? I mean, you should always start the planning. I say now while you're capable, while you're able to do it, and before you need it. Once something happens to you, then it's too late for you to do any planning at all. Next slide. So we're going to talk about the common estate plans that we often see when we are dealing with clients. So most people want to plan because they want to control who receives their assets, who gets what, when, and where, and how. There are really 6 basic ways to plan your estate. The biggest one is to do nothing. Just leave it as it is, and it'll take care of itself when you pass away or when you're incapacitated. Or you can put documents in writing that clearly tells everyone, family members, friends, court, judge, what you want to have happen to you, who you want to care for you if you're sick in the hospital, unable to care for yourself, or after you have passed away. So some of those documents may include doing a healthcare proxy. So a healthcare proxy is a document where you are appointing or designating, and you're telling someone in writing who you want to make medical decisions for you if you're sick and you cannot make those medical decisions for yourself, right? So in the healthcare proxy, you can also determine, if I pass away, do I want to make organ donations, and what body parts do I want to donate? You can talk about how long you should remain on certain life-supporting procedures. The next document that we typically talk about is the power of attorney. So the power of attorney is a financial document that allows you to name someone to make financial and legal decisions for you. So again, if you can't make decisions for yourself, who is going to pay the bills for you? Who is going to go to the bank, who is going to make any legal decisions for you. You want to have that in writing and available so that the people that you are appointing, one, know that you've appointed them as your agent, and two, you may also want to be able to give these to maybe your bank so that if someone else needs to access your bank account because you're unable to access those accounts, your bank accounts, that they have the legal authority to access these accounts. And then one of the things that most people know about is having a last will and testament. I think that's a very well-known and common way to plan your estate for when you pass away, and determining who gets your assets. And then another method of planning your estate is having a legal trust. Okay, so you can go to the next slide, please. All right, so plan number 1, doing nothing, right? So you're here, you decide, all of these legal stuff, I don't want to be bothered with it. I don't want to think about death. I don't want to think about dying. I don't want to think about being sick and can't make decisions for myself. And so you do nothing, right? So you just leave it to chance. If something were to happen to you, for example, if you're incapacitated, as my colleague spoke about, you would be subject to control by the court, by someone else that you may not want to be in control of making medical or financial decisions for you. So doing nothing, while often seems to be a good idea because you don't want to face the question or you don't want to think about it, that's one of the things that you should avoid at all costs. Put in place even simple documents, simple written instructions with the assistance of a lawyer or someone who is well versed in this area that will help you and guide you and allow you to determine who makes decisions for you and who controls your assets. Next slide, please. Okay, we can go to the next slide. I'm sorry. All right, so while we are waiting for the next slide to come up, okay, there it is. So I sort of put together a little chart of what happens to all the stuff that you own when you die without a will in New York, right? So you may be saying, if I pass away and I've got stuff that I own, but I don't have a will. You know, some people think that the state will end up getting their money. Some people, they just don't care who gets their money. But the state of New York will determine who gets your assets and in what amount. For example, if you have a spouse and no children, the spouse inherits everything. If you have children and no spouse, the children will split everything equally. One of the common thing I see a lot in my profession is that people who are legally married decided that they no longer want to be in a relationship with each other. And so they separate. They live separate and apart, but they don't legally get a divorce. And then they're surprised, or their family members rather are surprised when their family member pass away and this estranged spouse ends up getting everything. And that is because the parties are still legally married. And in New York, you have to prove that one person abandoned the other. And living separate and apart from each other does not prove abandonment, right? So if you're going to separate from your spouse, I say go get a divorce or get a separation agreement that outlines what happens to your assets when each of you pass away. Next slide, please. Okay, so the next plan that I talk about is the last will and testament. So the last will and testament expresses your wishes. So you're putting together this document that basically overrides what the states tell you who gets your assets. So if the state says, if I pass away and I have a spouse, my spouse gets everything. In your will, you can say, my spouse may get half of it and my dog gets the other half. I'm just kidding, your dog doesn't inherit. But you can designate who gets your assets in your will and in what percentage of your assets they will get. One popular thing and something that I always touch on a little bit about a last will and testament is for parents who have children, minor children, children under the age of 18, right? If something happens to the parents, whether or not that's incapacity or death, you will need someone else to take legal and financial custody of that child. And so how do you tell the court who you want to have custody of your children if something happens to you? A lot of people put this in their will. In their will, they would say, if I pass away, I have a spouse, my spouse will get custody. If I don't have a spouse, then I will designate someone else who will be able to take my children, raise them until they are at least 18, and secure their funds while they're minors, take care of them with the funds that I have left behind so that they have a decent life, so that they don't end up in the system. Right. So that is something that I always talk about. So you can put guardianship of children, minors. This is a separate type of guardianship from what Tamara spoke about earlier. So you can put guardianship of children in a will, or you can put it in a standalone document. Next slide. So something with the two plans that I've discussed so far. The do nothing plan, where you do nothing, and the will is that when you pass away, in order for legal title to be transferred out of your name, you or your estate, your assets have to go through this process called probate. If you do not have a will, then that process is called administration. But you have to go through the court system in order for your assets to be transferred to the people that you want them to be transferred to. So in probate, not only are your assets distributed according to your will, but your debts are also required to be paid. So funeral bill, administration costs, all outstanding debts that you have needs to be paid before your beneficiaries or your loved one will get any of your assets. So if your bills or your debts supersede the assets that you have, in the end, most likely all of your assets will go towards paying off your creditors, and your family may not have any assets to inherit. Also, you can go to the next slide, please. So one thing about probate, as I said, it's a court process, and probate is time consuming, and there are a lot of costs associated with probate, right? So you can expect typical timeline for probate proceedings in New York State is anywhere from 9 months to 2 years. 9 months is like really something that I'm hopeful, but it never really happens, right? So it typically takes a year or more for your assets to go through the court system. So with a will, typically you will designate someone called an executor. An executor is the person who will collect your assets, who will take the will to the court. The court will decide whether or not your will is valid, and if it's valid, admit it to probate. And then the executor will be responsible for paying all of your debts, collecting all of your assets, paying all of your debts, and distributing what is left over to your loved ones. All of the costs and fees associated with probate is going to come from whatever assets you have left behind. So some assets that go through probate, not all assets go through the court system, only assets that are titled in your name. For example, if you have a bank account in your name, that will go through the court system. If you have a real estate in your name, that will go through the court system. Stocks and bonds, those assets titled in your name alone go through the court system. However, there are certain other assets that you may own that does not go through the court system. For example, if you have a joint bank account with someone else, the first person who passes away, the survivor, will get that bank account outright without having to go through the court process called probate to get the bank account. If you have joint property where more than one person's name is on the deed, that's a deeper discussion for later, but it depends on how the deed is titled. You may or may not have to go through the court system to transfer title to someone else. Certain other assets, for example, life insurance policies, bank accounts, investment accounts that has a designated beneficiary do not go through the court system. They go directly to the people named as beneficiaries. And one of the things I always try to tell my clients, if you have minors under the age of 18, name someone who is an adult who will be able to manage those funds for the minors, because you don't want to have all these proceeds end up in the court system, and then it becomes subjected to your creditors. Retirement accounts. Retirement accounts that you have do not go through the court system. So these are, as long as you name a beneficiary to these accounts, they will not go through the court system. But if there is no beneficiary named on any of these accounts, they will end up in this process called probate. Next slide, please. All right, so we can go to the next slide. We spoke about the time that it takes to probate an estate in New York, and typically that's because state law dictates that after the executor is appointed, or the administrator, if you have no will, after that person is appointed by the court to oversee your estate, then they must legally wait at least 7 months from the date they are appointed before they can close the estate and distribute the funds, right? So during the probate process, your loved ones may not have access to your money. And then the last thing that we're going to talk about is a living trust. So basically, what is a living trust? I always say, think of the living trust as a box that you're putting all of your stuff in while you're alive. And that box is holding your stuff. You will retitle your house, your bank accounts into the name of that box. So you'll give that box a name, and you will retitle all of your assets into that box. So the roles are in a trust is that you will be the grantor. If you're setting up a revocable living trust, you will control all of the assets, all of the money in the trust while you're alive. It will be as if nothing really changed except for the title to your assets. That's the only thing that will change. For taxes, the IRS disregards the trust for tax purposes. So you still file your taxes on your 1040, and you still pay your taxes as an individual. However, if you are no longer serving as the trustee, the person who is handling and managing the assets in the trust, and someone else step in, we call the successor trustee. You can go to the next slide. We call the successor trustee. Then the successor trustee will have to file and pay a trust taxes for the trust itself. You can also go to the next page as well. So, you know, with the trust, you retain control. You keep control. You can buy and sell assets. You can take assets out of the trust. You can put assets in at any time. You can cancel stuff. And the trust itself contains instructions about who gets your assets after you pass away and how they get these assets. So unlike a will, when you pass away and the will proceeding ends, the court states that your loved one must be given these assets before you can close the proceeding. With a trust, you can keep the trust going long after you have passed away, and you can decide at what age, what stage of your relative's life they will get access to the funds in the trust. So the trust helps you, it's sort of very dynamic, and the trust assets, all the assets that are in trust do not go through the court system, because you're essentially taking title of those assets out of your name and putting title in another entity. So for purposes of this conversation, you no longer in theory own the assets. You still control them, you still own them, but for estate planning purposes, they will not go through the court system. Next slide. Right, so as I said, you can determine when your beneficiaries get their inheritance. You can give it to them all at once when you pass away. You can give it to them installment over time, or you can say, you know, they only get the income that is generated from these assets monthly, quarterly, yearly, but the assets themselves are going to remain in the trust, maybe for another generation, for grandchildren, or for some other purposes. So the trust allows you to fully sort of control. Some people say that the trust allows you to control from the grave what happens, but I think it's more dynamic, and it gives you a way in which to over time to gift your assets to your loved ones. Yeah, so that is my presentation, and I will answer some questions. Let's see.
Okay.
So thank you so much, Ms. Pritchard. I think that what we're gonna do, we're gonna go straight to Ms. Walker. When she's done, then the two of you will take the questions. Please keep the questions coming on the chat, but we want to go to Ms. Walker, and then when Ms. Walker is done, then Chima, you can start reading out the questions along with Chico, and the two of them will answer. Ms. Jordan had to be excused because she previously informed us that she had a conflict later in the evening. So
Still here.
Ms.
I'm
Walker?
still here, and I'll stay on.
Oh, you are? Oh, great.
Yes.
Thank you.
Yes.
Great. Okay. All right, Ms. Walker, the floor is yours.
Hi. Good afternoon, everyone. Thank you again for being here. So my part of the presentation is really dealing with the certainties. There's two certainties, death and taxes. So I'm going to talk about what happens when you die. And while Kalichi is going to put our presentation. And just to let you know that part of my presentation does overlap with Ms. Jordan's and Ms. Pritchard, because it all really ties in. So this is the beginning of my presentation. So let's go to the first page. That would be, yep. So I want to first give you some information. So surrogate court in New York City, in each county, New York City has a surrogate court. So the next slide, there is New York County. And if you Google surrogate court in New York City, you will find this information. I took it right off the website. So in New York County, and that's Manhattan, but when you're talking about the county, it's New York County, the city of Manhattan. So these are the two surrogates. There are two surrogates in Manhattan, and this is their location, and this is their direct information if you need it. Let's go to the next slide. The Bronx has one surrogate, and this is their location. Next slide, please. Queens, this is a new surrogate. Previous to this, it was surrogate Kelly, and surrogate Cassandra Johnson was just elected as the surrogate in Queens last fall. So she started her term in January. In Kings County, we have surrogate Montalbano and surrogate Graham. And this is their contact information. So if you're filing a petition in each of the counties, you know where to go. And of course, in Richmond County, and that is Staten Island, this is where the surrogate court is located. Okay, let's go to the next slide. Thank you. Okay, surrogate court cases. As Ms. Pritchard articulated previously, this is where we go to probate a will. So if you have a will, the will is submitted for probate to the surrogate court in the county where you reside. So if you reside in the Bronx and you die in the Bronx, that's where your will would be probated. Typically, the surrogate court where your will is probated is the location that's on your death certificate. So on your death certificate, if it says if you died in the Bronx, your will is probably going to be probated in the Bronx. Now, there's some intricacies dealing with that, but typically, if it's on your death certificate, that's where your will be probated. In some instances, if the Bronx is on your death certificate, but you were residing in Brooklyn, you can probate the will in Brooklyn, but you'd have to explain why you were probating in Brooklyn, Kings County, and your death certificate says the Bronx. You would be surprised how many times Ms. Pritchard and Ms. Jordan and myself have that situation where we have to explain to the court why one county is on the death certificate and we're probating in another, or vice versa. As Ms. Pritchard articulated earlier, if you don't have a will, we're going to file a proceeding for administration. That means you died intestate without a will. So in New York State, you can either create your own will, and your will is to plan how to distribute your assets when you're no longer here. So that's under your control, right? If you do not have a will or a trust, then New York State has a will for you. And the state decides how your assets will be distributed. And Ms. Pritchard went through, who would get your assets if you do not have a will, you die intestate. So she's already explained that to you. If you're married, it would go to your spouse. If you have a spouse and children, 50%, the first $50,000 would go to your spouse. Then the balance of your estate, 50%, would go to your surviving spouse. And the other 50% would go to your children in equal parts. So, for example, if you have 2 children, 50% of your estate would be divided equally among your 2 children. So that is the estate plan that New York State has for you if you do not create your own estate plan. And Ms. Jordan talked about control. So you no longer have control how your assets will be distributed when you're no longer here. It will be under the control of the state, and that's ETPL 4.1-1. But if you have a will and you decided you wanted control, that would be ETPL 3-1.1. Okay. The surrogate court also handles adoptions. So this is where you would go when you're probating a will, or you're filing a procedure for administration when you do not have a will, or you're handling adoption. So typically, these are the major areas that the surrogate court will handle. Next slide, please. Okay. So I think we missed, yep. I think we go back one. Nope. Okay. So the surrogate court handles administration proceedings, as I mentioned, adoptions, and some guardianship for minors and adult with intellectual disabilities. So Ms. Jordan talked about guardianship in the Supreme Court, and that is under Article 81. Here in surrogate court, it's guardianship for minors and adults with intellectual disabilities, and that's under Article 17. Also in surrogate court, they handle inheritance disputes. Next slide, please. Okay. So in probate, you have a will. There is a will, okay? Usually when you're probating the will, you want the court to validate your will. So when the decedent has a last will and testament, so you die testate, so you have a will. So the will is filed with the surrogate court in what we call a probate proceeding. And the court now will validate the will decide whether this is a valid will. Ms. Pritchard earlier mentioned that you may want to have an attorney draft your will because there is an execution proceeding that goes with a will. So the attorney will have you come into the office, her office, and will discuss with you how you want your assets to be distributed when you're no longer here. And after the attorney has reviewed it, memorialized it in writing, then there's an execution committee or execution of the will that happens. So you have 2 witnesses. The witnesses, after you review the will with your attorney, make sure that this is really what you want. Then 2 witnesses are invited in. You publish your will. You say to the witnesses, this is my last will and testament. You have to be over 18 years old. If you wear glasses, please wear your glasses when you're executing your will. And then the attorney will handle the execution of the will. And there's presumption under the law that if there's an attorney that handles the execution of your will, then the will was executed validly. So I know a lot of people go online and they use AI and GPT chat to create their wills. But what we're seeing is that there's a lot when we see wills that are being probated or wills that the surrogate's like, we can't probate, this will cannot be probated, cannot be validated, is because there's a lot of errors. The beneficiaries are called distributees. They're called the wrong name. There's not enough information, or it says beneficiary, and then there's no beneficiary listed in the will. So there's a lot of errors that can happen. And when an attorney drafts the will, there's a presumption that the will is valid. Okay. The surrogate determines if the will is accepted by granted a decree and appoints the executor. So the person who administers your will, once the court agrees or validates it or grants a decree, becomes the executor. And this is the language that we use when the will is probated. Let's go to the next slide. Okay. So in a probate proceeding to probate the will, this is some of the documents that you would bring. For example, if Ms. Pritchard or Ms. Jordan or myself is going to probate the will, then the documents that you would need to bring to the attorney's office is you would bring the original will of the decedent. The decedent is the person who died. You bring an original death certificate because we need to submit these documents for probate to the court, the surrogate court. The funeral expense, a family tree, and you may even need an heirship affidavit. And that depends on how you are bequesting your assets, so that the court really understands really your intention, and that all the appropriate individuals can receive notice and when the will is filed and probated before the surrogate will grant a decree. Next, please. Okay. Now, administration is controlled by ETPL 4.1-1. And again, this is when you die intestate. You die without a will, and New York State has an estate plan for you. So let me recap. Either you create your own estate plan, and that's when we probate your plan in the will, or New York State has an estate plan for you. And that's when New York State says, this is the law of the land, and since you died intestate without a will, this is how we're going to distribute your assets. And it's going to go by your bloodline. And your bloodline becomes who are your distributees of your bloodline. So your bloodline becomes your surviving spouse, your children, your parents, your siblings, and then your cousins. Okay. So after siblings, nieces, siblings, nieces, nephews. But if you have no family, aunts are gone, everybody's gone, your assets may go to your cousins. So it goes to first cousins. So let's say you don't have any children, no surviving spouse, no parents, no siblings, no nieces and nephews. Then we go to cousins. They may be far reaching. They're not part of your nuclear family. They're part of your extended family. And you haven't seen that cousin in 30 years. But guess what? Your cousins now get your asset because there's nobody else around and you have no estate plan. So New York State, it will go to your cousins. And if you have no family, your asset will estate to New York State. Okay. Yes, Pastor. If they can't find anyone, and you have they cannot find even cousins, then your assets will go to the lovely New York State. Okay. The surrogate court will appoint an administrator for the decedent's estate. And That's how your assets will be distributed. Okay, next slide. Okay, so what happen? How do we move forward when the decedent die intestate without a will? These are the documents that you would provide to Ms. Jordan or Ms. Pritchard or myself. You need the original death certificate. Okay, you need the funeral expenses, you need the family tree, you need an heirship affidavit. An heirship affidavit and the family tree is usually executed before a notary by someone who knew the family, right? So if you have a surviving spouse and you have children and they're going to be the distributees of the estate, then you want to get someone else to sign the family tree before a notary and the heirship affidavit. So the family tree will have the name of the decedent, the spouse, the children, and then someone who's known the decedent for maybe 20 years. I mean, if the decedent is 4 years old, you want someone who's known them for 20 years. That person can be a pastor, a doctor, the lawyer, family lawyer, a family friend who kept in touch with the decedent, who knew the decedent, who knew the heirs of the decedent's body, who knew the spouse, who knows the family, and is willing to sign a document saying, hey, I knew the family, and these are the children, these are the natural born children, there were no adoptions, or there were kids that were adopted. So if you adopt children into your family, they become part of your bloodline now. They become, if you legally adopted them, they become part of your family. The heirship affidavit is an affidavit that tells the court, yes, I knew this person, I know their family, I know their history, I know their children, I know, these are the folks in their family, and you're signing that before before a notary, and it's filed in the court when the petition is filed. Okay, so that's the difference between administration versus probating your will. Okay, so I'm here for any questions, and that's an overview of surrogate court and what happens when you die, whether you die with a will or whether you die intestate without a will, and that determines the level of control you have over your assets. Now, dying with a will allows you to what we call transferring your inheritance to your family. When you die without a will, again, it could go many ways, and sometimes not the way you really wanted your assets to be distributed. Thank you so much.
Thank you, Ms. Walker. Thank you very much. And I will turn it over to Chairman Chikwo to take turns to ask the questions in the chat. And if you haven't had a chance to put in a question, please go to the chat, type in your question based on the presentation or based on prior concerns that you had before today. Thank you.
All right, thank you. So our first question, I believe that's coming from the first presentation. How does the court decide if a person is incapacitated?
So the court makes a determination by conducting a hearing. And one of the questions that I had asked earlier is, how quickly can your case be heard before a judge? So one of the issues is that if someone files court papers seeking to serve as your guardian, the court can actually appoint a temporary guardian before the hearing. So that means that someone can temporarily manage your affairs before the hearing is conducted. And typically, the court has 28 days to schedule the case for hearing. And in the hearing, the court will listen to the testimony. It can be a doctor, it could be a social worker, but the court will heavily rely on the eyes and the ears of the court, which is a court evaluator, and make a decision based on your ability to perform your activities of daily living, such as whether you can dress yourself, whether you can feed yourself, whether you can manage your finances. And the hearing can be conducted in person or it can be conducted by video. But that judge and that judge alone can basically change your life within a short period of time and will make a determination whether that person who is appointed as a guardian based on the standard clear and convincing evidence will have the control over your affairs.
Okay. The next question following, I'm not sure if this was answered already, but it says, since the will is a legal document, is it advisable to get help doing it, or is it okay to do it by yourself?
Yes, so the will is a legal document, and I always advise to get assistance from an attorney to help you create the will. As Ms. Walker stated in her presentation, there are certain requirements, especially when you're signing the will. Certain steps must be taken to ensure that the will is valid. And so you'd want someone who knows the ins and out of that to help you make sure that all of those requirements are met.
All right, next question. Can a legally married person be able to have an estate plan without the spouse?
Again, that's a yes. When you're doing an estate plan, typically spouses, they will plan their estate together jointly, but each spouse will get their own separate documents, right? So there is no joint will where, you and your spouse is on the same will. Each individual spouse will get their own documents. And sometimes if your spouse does not want to plan, then you should go ahead and plan for yourself.
The next question, I'm not sure the context. Okay. So the next question is student loan / loans part of loans that has to be paid before you, wait, hold on, sorry. Is student loan / loans part of loans that has to be paid before your beneficiaries get the assets?
Do you want to take that one, Pam?
My understanding is that student loans die with you, but I haven't looked at that law for a while. But to the best of my knowledge, your student loans die with you, and they're not part of the liabilities to the estate. That's my understanding. But please, everybody, Google that because I haven't looked at it for a while. You still have to pay the tax. You don't get away from taxes, but you may get away from the student loans that are not paid. But other liabilities, for example, if you have real property, the property taxes, utilities, your credit cards, you could negotiate with the credit card companies to reduce or pay them pennies on the dollar based on how large your estate assets are and how much cash. A lot of what we find, and I work with Tamara and Miss Jordan and Miss Pritchard a lot on various probate matters. A lot of times when the decedent dies, their biggest asset is real estate, right? So they own like real estate because particularly in Brooklyn, in Clinton Hill and Bed-Stuy and Fort Greene, you're looking at brownstones that were bought 30, 40 years ago that are now worth $3-4 million. So the decedent was very asset rich, but cash poor. So the property typically has to be sold. And then, all of the liabilities of the estate is paid. But to the best of my knowledge, student loans do die with you.
All right, following question. What is an example of an asset that would not be titled to you?
Individually? Okay, so I think Ms. Pritchard talked about this. If a husband and wife own a home and they're both on the deed, by operation of law, the property would go to the survivor of the two. Okay, so that's an asset that's linked directly. If you have a bank account, if there's a husband and wife, and you have a bank account and the bank account is only in one person's name, then that asset would be probated in the name of the individual who owns the account. If the spouse owned a property prior to marriage, let's say, and only the wife's name is on the property, and then the wife dies, then that asset would have to be probated in the wife's estate. Okay, so again, if the wife dies first and they own property together when they were married, they're, both names are on the deed, by operation of law, it'll go to the survivor. But if the wife has assets in her name only, then that would be part of her estate and that would have to be probated. Now, Ms. Pritchard spoke earlier that if she has a surviving spouse, the surviving spouse would be the petitioner, whether she has a will or not. He would be the petitioner. And if they don't have children, 100% of her asset would go to him anyway. But if they do have children together, or her children, then 50% would go to the surviving spouse, and then 50% would be divided equally among her children. So an example of an asset that would have to be probated is if the asset is only in the decedent's name. Ms. Pritchard, Ms. Jordan, did I say that right?
I'm sorry, if the asset is only in the decedent's name,
Yes.
then yes, only the decedent's that asset is probated in the decedent's estate.
Okay. The person who asked the question, did we answer your question, or was there something else you wanted to know on that?
Okay.
Uzo said yes, it was answered. Thank
Okay.
you. You're welcome.
And I just wanted to touch on a quick point before we go to the next question. When we're talking about assets and who gets your assets, one of the questions I've been asked a lot is, can you disinherit your spouse? Can you make sure that they don't get anything at all? And so I would say if you want to disinherit your spouse, maybe you should get a divorce. If you have a prenup, your prenup agreement can dictate who gets what in the event of death, but you cannot, in New York State and for most other states that I'm aware of, you cannot disinherit your spouse. Your spouse is entitled to a share of your estate, which is at least 1/3 of everything that you left. And that 1/3 share does not only include assets that are going through the court system. They include non-testamentary assets, so some assets that would bypass the court system, say, for example, a joint bank account with someone else, retirement account that's been designated to a different beneficiary. So the 1/3 share for the spouse will be added up when you count up every single thing that the deceased person owned.
Right. So just to follow up with Ms. Pritchard, so if you try to disinherit your surviving spouse, then your surviving spouse can do what is called a right of election and demand 1/3 of the decedent's assets. So the surviving spouse, and I think that's just been developed through common law, where in the past people tried to disinherit their spouse, and the law says, nope, we're not going to do that. We're going to give the surviving spouse an option to come into court and do a right of election and get some of the assets.
Right. And some people try to be very slick. They will say, I'll give my spouse $1. That doesn't work either. Okay.
Yes.
Okay, the next question is, explain a pour-over will.
Okay, so a pour over will usually comes in a situation when you have a live-in trust. So all of your assets, you have a live-in trust, you set up the trust, but even though you put the trust together, we still have a will that's really a backup will. And so if all of your assets are in the trust, then there is no need for that will to be probated. However, if you leave some of the assets out of your trust, the purpose of that will, pour over will, is to tell the court that they should use the will and put the assets that you've left out of the trust that's still in your name into the trust itself. So essentially, you're sort of pouring the asset out of your name, out of the probate proceeding, and into this trust instrument. So whenever we draft trust and revocable living trust, we always draft a companion will that tells the court that if any assets are left out of my estate when I pass away, it should go into my trust. And a typical asset that typically would be left out of your trust would be shares owned in a co-op. A lot of co-ops don't like trusts, right? They don't want to transfer the shares or the stocks to a trust. So you would still have to own those stocks in your name until you pass. Your executor will probate your will, and the will say, now the asset, this shares or the value of the share will go into my trust, and the trust will determine who gets my stuff.
All right. Going to move along now. Can you use a legal Zoom to create a will?
Yes, you can, but should you? As I mentioned before, and I'm going to let Ms. Pritchard follow up on this also, but we are appointed guardian ad litems by the surrogate court, where when a will comes in, I know Ms. Pritchard and I and Miss I'm not sure if Miss Jordan has us yet, but I'm sure she will in the future, where the surrogate will ask us to review a petition and write our recommendation as to whether this will should be probated or not. And I have seen or experienced wills that come in that are so wrong. There's so many errors. And, an attorney did not draft this. The individual, the decedent, that we call them the testator before they die, decedent when they die, may have gone to GP Cheat Tat or LegalZoom or some other other online programs, and the language that is used is instead of a beneficiary, they'll call the person a distributee. Instead of a bequest, they'll have different terms. It's not signed at the end by the testator. There's no witness attestation. A witness attestation is two individuals, usually unrelated to the testator, that witness the execution of the will. And, they sign that they saw the testator sign the will, that the testator speaks English, that, the testator indicated, published that this was their last will and testament, and that, they did this of their own free will. And then this attestation is signed by the two witnesses before a notary and is submitted with the will for probate. So, I'm not saying all the programs out there are incorrect, but we have seen and we have CLEs with the surrogates, particularly in Kings County, and they've seen examples of wills that are not properly drafted and are not properly witnessed or executed. And that's why you go to an attorney, because the presumption under the law in New York State is that if the will is prepared and executed by an attorney, the execution of the will is overseen by an attorney, there is a presumption, and there's case law on this, and there's a statute on this, that the presumption is that the will was executed validly, and that the will should be submitted for probate. And when you have a LegalZoom or GPT chat or some other AI prepare it, that presumption is lost. And if that presumption is lost, your will may not be probated. And instead of it, ETPL 3-1.1 controlling, and it goes to where you really want it to go, now we go over to EPTL 4.1-1, where New York State says, nope, this is how we're going to distribute your asset, and then it doesn't go to the right place. So there is a risk when you don't use an attorney that your will is not going to be probated. And you've worked so hard for your assets, and you want it to go where you want it to go and control. Do you really want to use that risk? Do you want to be under that risk that it's not executed properly and it's not going to be probated by the court? Ms. Pritchard, do you have anything to share with us on that?
No, I totally agree with you. And I've noticed that a lot of these online software, they're made for, everyone generally. So they are not specific to any particular state. And each state has their own laws with regards to what makes a will valid. And when you use these software, it may not be following the rules, and so the will not be probated. And I've seen many wills that have been self-drafted, and many times the court will ask if I can explain what the testator meant by this paragraph in the will, because it's so confusing, it's not clear. And then sometimes they don't even put a beneficiary's name in the will. And so, that drags out the proceeding. The court can also have what we call a will construction proceeding, because they don't understand what the testator was trying to say, who gets their assets. So it's always better to have the assistance of an attorney who practices in this area of law help you with drafting your will. I've seen wills drafted by other attorneys who do not practice trust and estate, and they mess it up as well. So go to someone who knows how the will should be prepared, how it should be executed.
And can I just chime in for one moment before we go to the next question? So you also have to consider a possible will contest. And that can be a very difficult process. And I had a case many years ago where someone reached out to one of my clients and said, you were going to inherit this large sum of money. And lo and behold, the public administrator discovered there was another will that excluded my client, and spent 2 years in litigation. And so if you go to, as my esteemed colleagues indicated, if you go to one of these softwares and a will contest comes up, who's going to defend you? If you go back to the software, they may reimburse you for what you paid for, but they're not going to cover you for the cost of litigation.
Okay, the next question is, can you name more than one person to make joint medical and/or personal decisions for you when you are incapacitated?
So the rule or the law in New York State is that when it comes to a healthcare proxy or a medical proxy, you only appoint one person. So you appoint a primary person who will make healthcare decision for you. And then you would name backups or successors if the person you really want to make the decision for you is unable to do so. Now, when it comes to making financial decisions with a power of attorney, you can name multiple people to act together.
Or separately, as the case may be. There's a section on the short form and you can Google this form in New York State, dual power of attorney, the short form, where there's a section where you can list more than two people and you can specify that they act separately. So one of the agents, so on the power of attorney, you have the principal and the agent. You're the principal because it's your power of attorney that you're assigning to somebody else to step in your shoe. So you can have more than one agent. And, let's say that, Ms. Pritchard and myself are the two agents, and I'm in Italy next week and something happens and Ms. Pritchard has to make the decision, then she can act separately. So we can act together or we can act separately.
All right. Next question. Can you please elaborate on funding a trust and how much does it cost to make a trust?
Sure. The cost of a trust will vary greatly based on a lot of things, the decisions that you're making regarding the trust, when distributions will be made, how long the trust stays valid or active after you pass away. So usually you will find a trust will go from anywhere from $4,000 to $10,000 and upwards. And as I said, it greatly varies based on the specific of your trust and your specific situation. Now, to fund the trust means that once the trust document is signed and executed, funding the trust means that you are transferring title of assets out of your name into the name of the trust. So for example, if I have a trust and it's the Pritchard Living Trust, and I have a house and it's titled in my name, Maureen Pritchard. So to fund that trust with that house, I would be using a deed to transfer title out of my name into the Pritchard Living Trust. You can also fund trusts with other assets, bank accounts, stocks, bonds. So funding the trust means you're transferring title out of your name and into the name of this this entity that you've set up.
Okay, the next question is, how does New York State get involved in your assets when you have no will? Is it when the estate are being contested?
So how New York State gets involved in your assets, and do you mean how New York State decides or determines who gets your assets? If that's the question, when you pass away and you pass away intestate, one of your family members may start a proceeding in the surrogate's court, as Ms. Walker explained earlier, and they will file petition. And based on that petition, if you do not have a will, then state law, New York state law will determine who gets your assets and in what amount. So the other part of that question that maybe that may be asking is if you pass away, you don't have a will, but you have assets. Also, the estate or your estate can be referred to the public administrator. So every county has a public administrator who is assigned basically to administer an estate of someone who doesn't have a next of kin or a relative to administer the assets that are going through the court system. And anyone can make a report to the public administrator that someone has died, they have assets, and the public administrator will commence a proceeding to administer that estate.
All right. Does a subsequent written directive or note duly executed invalidate a prior will?
You want to take that, Ben?
Sure. So it has to, you can do another will, right? Because in the will, in the beginning part of the recitals, you can say, usually the language is that, this is my current will and it invalidates all other prior wills. Okay. So when you say a document or writing, it has to be in the form of a will, meaning, it has to have, the appropriate paragraphs. It has to be signed at the end by the witness. Actually, this was a bar question. The will has to be signed at the end. The witnesses have to sign after the testator. And if it's not duly executed the way it's supposed to under the statute, then the will can be invalidated. Oftentimes when, two original wills are found, the petitioner may file both of the wills, and then everyone who's listed in both wills would have to get notice. So the prior will, may have to notice everyone who no longer gets from the second will. And we talked earlier that usually what is probate is the original will. Well, there are circumstances where a copy of the will can't be probated. In fact, in Queens County, I think Ms. Pritchard has a case also in Queens County where we're probating a copy of the will. And how we do that is we get testimony from the witnesses. Again, another reason why an attorney should draft the will. We have, the two witnesses will have to come to court at some point and testify that, yes, this looks like the original will that was filed. We have to get testimony from the drafting attorney who may say, oh, well, I had the original will and I put it in UPS and it was lost. And, I had dominion and control over the original will. And yes, this is the copy. So if you don't have an attorney on the other end to say that, then this may go right into administration instead of probating the will. So I'm not quite sure who sent the question, but if they're saying there's another instrument, we call the will an instrument. If there's another fully executed valid will instrument, yes, then the most recent will can invalidate the prior will. Be careful. We have some complicated issues where, let's say, the mother and a surviving spouse, and she has two children, and 4 wills before, she always left it to her surviving spouse and her children. This last will was done when she was sick and she was heavily under medication, and now she's taken out all of the children. Immediately, will contest, right? This is where Maureen comes in. She loves the litigation like this. So Maureen, right away, there's a will contest. Mm-hmm. And they're like, whoa, wait a minute. Why are the children disinherited in this will, but not the 4 wills prior? So those prior wills is going to come in, right? And the court is going to, particularly if you have the originals, and the court is going to look at that and determine what's going on. Now, let me complicate it even more. Let's say that one of the children is a minor. Then we call Maureen and myself and Miss Jordan and say, we need a guardian ad litem to advocate for the minor, right? So now we have to fight for the minor and say, no, the minor is disinherited. We gotta come in and figure out what's going on. And we now help the surrogate figure out what's going on. We may have depositions, 1404s, where we have to now interview all the witnesses, interview the drafting attorney, figure out, was she on medication? Was she wearing her glasses? Did she speak English clearly? Did she understand what she was writing when she was writing? This is a whole lot of money, a whole lot of money. And it's coming out of the estate's asset. And a lot of times we're talking about 5, 2 million, a million, whatever it is, but it's coming out of the decedent's estate at the end of the day. And it's a lot of attorneys you're paying, right? So you got to be careful. You got to be careful, as Ms. Pritchard say, go to someone who has experience, to draft your will and to draft the trust instruments and to even set up LLCs. You could do assign things to LLCs and etc. So be very, very careful. But yeah, the most recent will knock out the prior wills, unless there's a will contest, in which case all the other wills may be reviewed by the court. This is such an exciting field. Look at how excited Ms. Pritchard is on the screen.
I know. I'm like, I get so excited when I hear about litigation because I want to jump right in. But as Ms. Walker said, it's time consuming and it's expensive. I have a case currently in Queens County Surrogates Court that we've been litigating since 2017. It's still ongoing. Right. So think about all the attorney fees over all those years that are being paid out. And the more attorney fees come out, the less money there is for your loved ones to receive.
The next question is, how do you will save the money in a bank?
How do wills save money in a bank?
No, it says, how do you will save the money in a bank?
Oh, okay. So, in this instrument called your last will and testament, you can sometimes what people do, they can say, I want to give the whatever is left in this specific bank account to this person, right? So you're stating it in writing in the will that you want the bank account to go to a specific person. The other way to do it is that you will say all the assets that I own and that is in my name at the time of my death will go to this specific person when I pass away. So you can make it a specific bequest or a residual bequest where all of your assets are gathered up when it's going through the court system, and that asset is given to the person who you name in the will.
Right. Can a person or group establish a trust for minor children of another?
Yes, you can establish a trust for minor children. And a lot of times you see this happen with grandparents, right? They will set up a trust for their grandkids. And some trust has specific uses. Sometimes they may set up a trust just to pay educational expense, college expenses for the minor. But so different people can gift. Basically, when you set up a trust for another person, a minor, you're basically making a gift of your money to the trust. And after you pass away, then the individual who you state will get the assets in the trust, will get those assets. One note, minors are not able to receive assets while they're minors. If you're under 18, they won't be able to receive those assets outright. Somebody else will have to hold those assets, manage those assets for them until they reach the age of consent, which is typically 18 years old.
The next question is, what about estates outside the United States? Can it be included in the will or trust?
Yes, you can include your assets that you own worldwide. Um, so a lot of times I probate assets for um, individuals who don't reside in New York State, or they reside internationally, but they own assets in the country, right? So if you own assets in New York, but you live somewhere else, then your assets will be probated in New York State. But when it comes to real property, houses, real estate, that may be a separate issue because real estate is transfer based on the laws of the country or the state in which the property is located. So if you live in New York and you have a house in New York and you have a house in Florida and you have a will, then what is going to happen is that you're going to have to start the probate proceeding in New York. And then because you have a property in Florida, you're also going to have to go to Florida. Your executor is also going to have to go to Florida and start another probate proceeding, which is called an ancillary proceeding in Florida to administer that real property. And one solution to getting rid of multiple probate is to use a trust. Transfer in all of your assets to the trust. The trustee will manage those assets no matter where they're located. Okay, so using a trust when you have real property in multiple states, is advisable. If it's just cash, then, it's going to be determined that the cash belongs to the state in which you reside. So, and what I typically tell people is that because each state have this different rules and regulation, and each country has their own rules and regulation, what they may want to do is if they have a property in another country, is to create a separate will that deals directly with the distribution of the property in that country. Some country has laws that tell you whether or not you have a will, who gets your stuff. There's no change in it, right? These countries are called forced heirship. So the law tells you who get your stuff, and that's it. But otherwise, I would say do a will in your home state. And then if you have property in another country, do a will in that country that determines what happened to the assets specifically for that country.
All right. What is the approximate attorney cost for guardianship and estate planning?
Let's have Miss Jordan answer this one for us.
Well, it depends. So I that's the short answer. So let's give an example. Wendy Williams, case right now, right? I can tell you without being involved in the case, and I'm familiar with who's involved, that this is an expensive case. And the reason it's expensive is because you have, and I'm not affiliated, so I put that disclaimer, you have litigation with Lifetime about having her, I guess, bio, on the screen. You have doctors coming in to determine whether or not, Wendy Williams is fit. Then you have court appointees, but typically speaking, a guardianship, it could be minimum, I would say minimum of 5,000 and upwards. It really depends and it also depends on the status of the case itself. Generally speaking, I do not get involved in an ongoing guardianship proceeding. And the reason for that is because if another attorney has already been involved and commenced the case, that means I have to take over what that attorney has done. And sometimes what that person has done may not be repairable. So I like to take the case from its inception and also determine, whether guardianship is the most appropriate route. So it really depends on what stage of the case it is. It depends on who is filing for guardianship. Are you filing for guardianship for someone else? Or is guardianship being filed where someone wants to serve as guardian over you? Sometimes you have family members. I have a situation right now where a family member, long lost family member, has just decided to swoop in, hop on a plane from Florida, who hasn't been around in many years, to run to a nursing home to see how their loved one is doing. And that's not, it's sad, but it's true, where you have a lot of people who, as I always say, come out the woodworks or try to figure out how they could benefit. In terms of estate planning, I'll turn that over to, my esteemed colleagues, in terms of what the estate planning would cost. But I would say to you, because I know a lot of information has been given thus far by myself and my esteemed colleagues as well, I would recommend a minimum, whether it's myself or my esteemed colleagues, to speak to an attorney. Just at least have a consultation with an attorney. It's worth the investment before you decide to use a software such as LegalZoom or anything like that. You rather talk to an attorney from the beginning than try to get an attorney in the middle of a case, because it's going to cost you more in the long run.
Before they chime in, I just wanted to say, this has been a very, very exciting session. It's usually our sessions are usually 90 minutes, but this has gone way over 120 minutes, and it is because of the interest generated by the topic and the amazing work that our presenters have done. But at some point, we have to call it an evening, and so we'll probably take 3 or 4 more questions, maybe give another 5, 7 minutes for responses. I see there are probably another 6, 7, 8 questions. We probably won't get to all of them. And so I have reposted the information of our presenters. I urge everyone to go to the chat function, take their information, and follow up with them tomorrow. They're amazing ladies, and they'll be more than happy to answer your questions. So Chima and Chiku will go ahead. 3, 4 more questions. We'll probably have about 5 to 7 more minutes, and then we'll call it an evening. Thank you.
All right, let's proceed. Are assets in a trust protected from lawsuits?
That is not necessarily an easy question to answer, just because it depends on the type of trust that you're talking about. And we didn't get deep into details about various different types of trust. You have revocable trust and irrevocable trust. But for this presentation, we're talking about revocable trust. So the person, the grantor, the person who is setting up the trust and putting their assets in the trust, those assets are not protected from creditors in a revocable trust situation. However, your beneficiary, once they are entitled to get the assets after you pass away, those assets are protected from creditor. So no credit asset protection when it's on the level of the person who set up the trust, but asset protection for the beneficiary, the people who will be receiving the assets from the trust.
The next question is, how about if the spouse in whose name is the property wills it to another family member?
So one of the things I always say, it's your stuff. You can give it to whomever you want, but there's always that restriction about your spouse right of election and getting a third of your asset. So if you have a property and you give it to somebody else, as long as that's not the only property you have, that's going through the court system, then you can give that asset to someone else. If it's the only asset you left behind, then and the spouse elects to use their right of election, then that asset is going to come back in the estate if it's already been sold. If it's not been sold, then the spouse would be entitled to their 1/3 share of that asset. So it really depends on how much assets you have that is going through the court system, and and who is getting those assets.
Okay. Can an attorney in New York prepare an estate plan for a person living in another state?
I generally don't advise it.
I'm gonna take that one, Maureen. Yes, you can do it, but as Ms. Pritchard said, we don't advise it. I don't advise it. If the person is in Florida and they were living in New York and then they moved to Florida, you could draft the will and you can put in the recitals that this will is under the laws of the state of New York, because Florida and New York have two different sets of rules, right? So, and if the attorney is going to draft it and the client is in Florida, that attorney should be admitted in Florida, right? Because if you're not admitted in Florida and you're trying to do a will for Florida, then you're practicing outside of your scope. You're not admitted to practice in New York, in Florida, so you're opening yourself to malpractice. So not a good idea. But in some instances, you can, it's up to the attorney whether they want to take that risk with their malpractice insurance. But you could draft, there could be a circumstance, let's say that the testator, the person who wants to draft the will, was living in New York and they've just recently moved to New Jersey, let's say, okay? You would put in the recital that this will is drafted under the laws of the state of New York, because they're not even a resident of New Jersey yet. They just moved a couple of weeks ago or months ago or something like that. So I can see a circumstance like that. But if the person has relocated to Florida, I personally would not draft that. I would, refer them to the local bar association to find an attorney that's admitted in Florida, or an attorney in New York that's admitted in the bar in New York and Florida, and that's willing to draft the will and knows the laws of Florida. Because as Ms. Pritchard mentioned earlier, each state has a different law. So,
sorry, go ahead.
No, that's it.
Oh, okay. So I just wanted to ask a question because there are two questions on the chat that are essentially one question, and that is when there's a conflict between the terms of a will and the terms of a 401k or the terms of a life insurance policy, what happens?
A good question. That's a very good question. So when I speak with individual about their estate plan, I talk to them about all of their assets, 401k, life insurance policies, everything that they own, just to make sure everything is sort of synced up together and your overall plan is going to be distributed as you want. So if you have a will and you say party A is going to get my assets, but on your life insurance policy and your 401k, party B is on those assets, then the party B that is designated on the assets will get the assets. So if an asset has a beneficiary designation, that will trump what is put into the will, right? So always make sure that your estate plan aligns. And as I said before, life insurance policies and 401k typically do not go through the probate court. They're outside of the probate process. They bypass the court system because they typically have a beneficiary named to those assets. So if you have a beneficiary named to an asset, then that asset does not go go through the court system. So your will does not affect who gets those assets.
Okay, the next question says, can a will be amended when the author is deceased?
Nope.
No.
No.
Nope. It's all done. End game.
You have to be alive. You have to have capacity. You have to know what who your family members are, who you want to give your asset to, what you own and what you want to give away and who you want to give those to. So that is capacity. You have to have capacity in order to sign and execute a will. So even if you're alive, but you're incapacitated, you still cannot change a will after incapacity, even though you're alive. And so you definitely can't change. I mean, I don't know how you would change it when you pass away, because you're dead, essentially.
Yeah, and just to follow up on that, and Ms. Jordan may want to chime in here. Now, if you're incapacitated, your guardian can draft a trust agreement for you, correct? Yes. Ms. Jordan, any final words
Yes.
on
Well,
trust?
no, I think you said it best. I think the takeaway, because I see we're going to be wrapping it up in a second. I think the takeaway is that myself and my colleagues wanted to give you a roadmap on being able to just start thinking about, what your affairs, what you want to do. And as you know, we live in uncertain times. So I certainly thank the pastor for the opening prayer. I hope that this presentation has been informative. I hope that your takeaway is that you need to sit down and really think about who should make decisions concerning your day-to-day activities. And I hope that whether it's myself or my colleagues, at least take the moment to say that I need to put things in order so that other people are not going to make decisions for me. And I thank you. Thank you all for sticking with us all of this time. I certainly did not intend on being here this long, but I think it was worth it. And I, just want to just say on behalf of myself, Ms. Pritchard and Ms. Walker, we are available. We are a community and we are here for you. And we thank you.
Thank you so much. I lack words to say thank you. That the fact that we've gone almost an hour past our scheduled end time is a testament to the robust information and presentation that you three ladies have done here today, and I couldn't be any more grateful. It's actually not a surprise. Heritage Church is a very warm, welcoming church, and the fact that you ladies have felt very comfortable with us tells me that one of these days, one of these Sabbaths, you guys will be dropping by to worship with us. So I thank you. I like words to say thank you. I'll have our pastor say a few words of thanks, and then our good Elder Joshua Nwachukwu, will give us the closing prayer.
That's been really good tonight. Thank you for coming and sharing a lot, not holding back. Thank you for that, and we appreciate your knowledge, and we're looking forward to you coming by Heritage Church one of these Sabbaths, one of these weekends to spend time with us. Elder Joshua, are you on?
Okay, I just want to say that Ms. Sonia here is so good that he brought these wonderful ladies this evening. We thank you, our brother, for doing this for us. Let us pray. Our Father in heaven, we thank you for bringing all of us together in this fashion, in this place this evening. We thank you, Father, for the knowledge you have given these ladies, and they have imparted it so well to us. Father, we pray that their coming this evening will not be in vain, that we will use them, we will use the knowledge the information that they have given us this evening to better our lives and the lives of our children. Father, thank you for all the people that have participated in this session this evening. Lead us back to our different beds this evening as we sleep. May your presence be with us, Lord. We pray in Jesus' name. Amen.
Amen. Thank you. Thank you, everyone. Next week, same time, 7 o'clock, join us for another session. Next week will be on a little more immigration. We'll also talk about careers, education, and how to adjust in very difficult times and circumstances. And so that will be a very informative presentation. And then we'll talk about Social Security, disability, and how to get benefits, who qualifies, and everything Social Security, disability. Thank you, and have a good evening.